Good afternoon. Welcome to Preservation Connecticut's Fall 2024 series of Talking About Preservation. This is our series of noontime chats that started during the pandemic. I'm Stacy Vero, a circuit rider here at Preservation Connecticut, and I'm pleased to be your host. Today, we're going to be discussing racially restrictive covenants in Connecticut's land records with Dave Ware. Mr. Ware is a retired corporate and business attorney who proposed and supported the 2021 law that invalidates racially restrictive real estate covenants. Before we get started with Dave's presentation, I'd like to talk a little bit about our organization for those of you who aren't familiar. Preservation Connecticut is the statewide private nonprofit historic preservation organization. We were founded in 1975 by a special act of the Connecticut General Assembly as the Connecticut Trust for Historic Preservation. Our mission is to preserve, protect, and promote the buildings, sites, and landscapes that contribute to the heritage and vitality of Connecticut's communities. We are statutory partners with the Connecticut State Historic Preservation Office, and we're proud to say that for 49 years, next year's our big 50th anniversary, we have successfully championed the protection of remarkable community assets all over the state by leveraging funding, advocating, forming partnerships, and promoting stewardship. Our office is located in the Eli Whitney Boarding House, which you see here on Whitney Avenue in Hamden. The boarding house is listed on the National Register of Historic Places, and it's the only surviving residential structure of the industrial village that's centered on Eli Whitney's armory, and it's served as Preservation Connecticut's headquarters since 1989. We have a staff of 9 preservation professionals and a board consisting of 21 preservationists from around the state. The staff that are listed here are always available to assist with inquiries. Jane Montanaro, who is our executive director, couldn't be with us today. That's why you got me today as your MC. Christopher Wiegren is our deputy director. You can contact Chris for information on historic preservation easements, our bi-monthly magazine, Connecticut Preservation News, and to arrange book talks for his book, Connecticut Architecture, Stories of 100 Places. Renee Trabert is our Making Places and Preservation Services Manager. You can contact Renee for information on redevelopment of historic industrial sites and for information on tax credit applications. Jordan Sorensen is our Development and Special Projects Manager. Jordan manages our communications and outreach to members through social media, email. She receives and monitors demolition notices from municipalities and prepares historic tax credit applications and nominations to the state and national register. Kristen Hopewood is our membership and outreach manager, and Kristen manages all the inquiries that come through our website. She provides member services, arranges special events, and is the editor of our Historic Properties Exchange, a free listing of threatened historic properties. And finally, our team of circuit riders, Field Director Mike Farino, Brad Scheid, Stacy Vero, that's me, and Stefan Danchik. We provide service in the field to homeowners, developers, municipal leaders, nonprofit organizations, museums, historic district commissions, and anyone who calls us. And we provide an array of preservation technical assistance, including community organizing, prioritizing maintenance and repair plans, historic designations, funding, and expertise related to archaeology. So through these chats, we have continued our mission to provide a forum to discuss every type of preservation topic that's come down the pike. So it's been a wonderful and enjoyable tool for us. Through them, we're able to connect with the public and hear what's on your mind. So please feel free to use the chat feature if you don't mind staying muted during the course of Dave's presentation. That would be great. But if you want to ask a question, you can raise your hand or put it in the chat, and Jordan or I will ask it for you. Or you can wait until the end of the presentation and you can ask it yourself. There's going to be time for discussion at the end. And as always, please feel free to reach out to us with any preservation related question. And with that, I am going to turn this over to Dave. So I'm going to stop sharing. I'm a little out of practice with this, so. All right, over to you, Dave.
Okay, I'm gonna see if I can then do my sharing.
And thank you for joining us today. Thank you for presenting.
Okay, is that up now on your screens?
It looks great.
Okay. How do I, I've got all of your lovely faces on the right-hand side, but it's blocking some of my slide. I'm not sure how to.
You can up in the
Maybe
above the faces, there should be.
I got it. I saw the little icons and I got rid of it. Okay. Very good. Well, so thanks for inviting me to talk about racially restrictive covenants in our state's land records. And I guess the first question is, what exactly are we talking about when we talk about racially restrictive covenants? We're not talking about, in this presentation anyway, we're not talking about informal restrictions or exclusions, neighborhood word of mouth, we don't like these people, we'd like them to be excluded from our neighborhood. Here, what we're talking about really are, in fact, how do I advance the slide here? We're talking about very formal, explicit, written, very well documented restrictions that literally forbid the ownership or occupancy or use of property on the basis of race, explicitly on the basis of race. These are documents that we find in our official public records. That is to say, here in Connecticut, in the land records of all of our, or at least of some of our 169 towns. They are, in fact, these covenants are the tools, the formal tools that have been used to both create and to legitimize racial segregation throughout history. And I say to legitimize it because if you think about it, documents that get filed and recorded in our official repositories of land records, they convey a sense of authority, of legitimacy. And so in my view, the fact that these documents are found in the land records themselves, that fact itself has contributed to the attempt to legitimize, if you will, racial segregation. And they are on another level. Actually, these covenants are documentation, if you will, of our history, right? The covenants are found in lots of different kinds of documents or instruments. You can find them in deeds in the land records. You can find them in agreements that have been written between two or more parties that have been subsequently recorded in the land records. You can find them in declarations, which are documents that one particular party or individual has written and just declared and then recorded on the land records. And in fact, you find these kinds of documents and instruments, frankly, all throughout the United States. And as I mentioned earlier, you can find them in many of the towns here in Connecticut. So here are some examples of what these restrictions look like. So take a look at the two examples that are in red type. They are almost exactly the same. The first one has been found in Manchester, in West Hartford, and in Hamden, and the third one in Newington. Notice the interesting, first of all, notice how explicit it is. No person of any race other than the white race shall use or occupy any building or any lot. And then this interesting exception that, well, it's okay if you want occupancy by a domestic servant of a different race domiciled with an owner or a tenant. At least that's what it says in the first example, domiciled with. In the third example, it's people of a different race employed by an owner or a tenant. And I mean, you could spend a lot of time talking about the potential differences between what that different phraseology might mean, but the intent is the same in all instances, which is basically to say only white people are welcome here on this property. So notice that the examples that are in black are examples of covenants that we have found in East Haddam. Short and sweet, the East Haddam one. No portion of the premises shall be conveyed or leased to any other than the Caucasian race. And you'll see that Caucasian and white, you'll see that used interchangeably in various places, both here in Connecticut and around the country. So those are examples. That's what we're talking about. So why are we here with Preservation Connecticut, which is, for the most part, focused on historic places and buildings and land and the like? Why are we talking about racially restrictive covenants? And I would suggest to you that the reason we are is that what you see here is a partial quote of language from your organization's mission statement. It says, historic places connect us to the lessons, techniques, stories, and people of the past. And they, that is to say, the historic places, evoke emotions and memories. Some are considered sacred. And the ones that we choose to preserve speak to our identity, and they reflect our values as a society. And I would say nothing could be truer. And I love the work that you guys do. And I would also suggest that if you take that same language and in place of the word historic places, you instead put historic documents, the same is true of historic documents, which is to say, documents connect us to the lessons and stories and people. And the documents that we choose to preserve speak to our identity, reflect our values. So if you're a Kamala Harris fan and you love Venn diagrams, you might depict it this way. What are the attributes that documents and buildings and places have in common? It is the thing that they have in common is in fact these attributes that were mentioned in your own mission statement, right? So you might say the purple area where these two intersect is the area of common interest, and that's why we're here talking about these things. So a little background that might be of interest to some of you about historical background about the use of these covenants. You can find racially restrictive covenants in historic sources going way back, to the early 1800s, even maybe in the 1700s. I'm aware of one in the early 1800s up in Massachusetts. You might say, though, that as a general matter, the sort of the modern legal or the more modern legal history of these of how the law has treated racially restrictive covenants can be traced to this case called Corrigan versus Buckley, a Supreme Court case arising out of Washington, D.C. in 1926, where neighbors in a neighborhood had gotten together and had agreed, we don't want Black people living here. And then one of those neighbors sort of broke the agreement and wanted to sell to a Black family, and a lawsuit ensued. And the lawsuit made it all the way up to the Supreme Court, and the Supreme Court ruled that these kinds of restrictions are actually permitted. There's nothing in the Constitution, said the court, specifically nothing in the 14th Amendment, that restricts or limits what individuals may or may not do. The court reasoned that the 14th Amendment is a limitation on state action. No state shall, right, is the language of the amendment. Now, that, of course, was consistent with the kinds of rulings that had been coming out of the Supreme Court and other courts for some time, all through the Reconstruction phase and the Jim Crow phase of our history. It's consistent with the famous Plessy versus Ferguson case, which established the so-called separate but equal doctrine. And so it's no surprise that after the Corrigan case, after the 1926 Corrigan case, in Connecticut specifically, you begin to see, now that the court has said these are legal, they're permitted, there's nothing wrong with them, you begin to see kind of a peak in the use of these provisions throughout the land records in the certainly somewhat in the 20s, but in the 30s, in the late 30s to late 40s is when they tend to peak. And that was the measure of things until in the late 40s, when once again the Supreme Court took up this issue in a case called Shelley versus Kramer. And here the court kind of takes a different direction and says that, and this is a case that came out of Missouri, they said, well, enforcement of these covenants is in fact not permitted because the enforcement of them actually does violate the Equal Protection Clause of the 14th Amendment. And notice the subtle difference here. The 14th Amendment, they say, hearkening back to their decision in the Corrigan case back in the 20s, that 14th Amendment addresses government activity, what the government may and may not do. So if the government uses its judicial machinery, the courts of the state, to enforce or uphold these kinds of racially restrictive covenants, that is unconstitutional. That is a violation of the 14th Amendment. Notice, though, that what the court did not do, the court did not say that the covenants themselves are illegal or that they're void or that they're invalid. And it did not say you can't use them anymore or that you must remove them from wherever they exist. It simply said enforcement of them by the courts is not permitted. So as a practical matter, the use of these covenants began to drop off. Not instantly, because for a lot of people, they were still reluctant to stop using them. But here, in fact, is the Shelley case is really the big case that for all intents and purposes, sort of put an end to the enforceable use of these kinds of covenants. Now, of course, shortly after the Shelley case in the late 40s, we entered what you might call sort of the early civil rights era here in the States, where both at the federal level and the state level, we began to have fair housing statutes, which then explicitly as a legislative matter, declared that the use of these kinds of covenants was unlawful. All right, so that's great. Now we've got now we have law sort of in two different versions of the law. One coming out of the courts under Shelley, saying that the covenants are unenforceable, and the second legal prong, if you will, coming out of the state and federal legislatures, saying that they're also, oh, by the way, illegal. You can't do them anymore. And so you might say, well, that's really great, and it is. But remember that in the land records themselves, these covenants sit there unrefuted, unaddressed, and they are, in fact, within the land records, the official land records of the state, they are the last statement of record concerning segregation. There's nothing in the land records that refutes them or that rejects them. In fact, in our research, we have found them in a number of towns, in some pretty significant numbers. Here you see a partial list of where we have found these covenants. So they're certainly not rare, and we continue to explore towns other than these that we have listed here, looking for the presence of these covenants. So that's been the case that is up until 2021, when frankly, yours truly brought to the attention of the Connecticut General Assembly that we ought to do something about this. And the General Assembly responded and enacted Public Act 21-173, which, among a couple of other things, addresses this matter of racially restrictive covenants. So what are the main points of Public Act 21-173? Well, it does really two, broadly speaking, two important things. First of all, for the first time ever, this new statute, this new Connecticut statute, actually comes out and declares these racially restrictive covenants to be void. Up until 2021, there was no Connecticut statute or court case that said that these provisions are void. Well, now we have a statute explicitly saying they're void. So that's the first important thing they do. And the second important thing they do in the Public Act is they have created a process for renouncing or rejecting these covenants in the land records, in the place where they reside, right? And that's done by way of two, not one, but two. And there's a story behind why we have two instead of one. But relatively simple forms that the current owners of property can record to identify the existence of these these racially restrictive covenants, and to state basically I reject it or I renounce it, right? And oh, by the way, the recording of these simple forms, there's no recording fee for them, which was an important point that I advocated for. We didn't want to. You shouldn't have to spend money to renounce or reject these kinds of offensive provisions in the land records. If you want to do so, you shouldn't have to pay anything. So there's no recording fee. And also importantly, for those of you who think about clean title and title insurance and the like, the statute specifically says that if one records one of these simple forms renouncing the existence of a racially restrictive covenant, that is not considered to be an encumbrance, a legal encumbrance on the property's title. This is a little bit of an eye chart, but just to show you, these are the two forms. You certainly don't need to try to hurt your eyes to read these things, but the forms are supposed to be. The statute says that the town clerk's office in each town across the state is supposed to have these forms available in the clerk's office for the public to use. In our experience going around the state to various towns, most towns have them. There are a few towns who are a little behind the times and really don't have these forms and either they'd never heard about the new statute or they heard about it but kind of forgot or whatever. But these, like I say, are relatively simple forms where you fill in your name and you put a property of your description of your property and a reference to where in the land records the offensive covenant resides, and you can then say basically I reject the thing. So what the statute allows then is it allows us to have what I call current, accurate, and complete records, and oh, by the way, and self-contained land records. I in particular am interested in knowing that the records are complete within themselves. The land records are complete within themselves, meaning that if you were to look only in the land records before the enactment of the new Connecticut statute, you wouldn't see either the Shelley versus Kramer case of 1948, nor would you see the later enactment of the state or the federal fair housing statutes, right? This is a way for the land records themselves to be within themselves a complete reflection of where people stand on the subject of excluding races. And Notice that the way that Connecticut has addressed this is in a way that there is no, pardon the pun, no whitewashing. There's no denial of the existence of these covenants. They're there. They're not erased. They're not eliminated. They are historical fact and they're there. What the statute says, though, is that we can put something on top of them to reflect the more current thinking of the property owners of both the legislature and what the legislature has done in declaring them void, and of the current property owners in saying that not only are they void, but I, the current property owner, I renounce this thing. So again, the covenants are not eliminated from the records. You preservationists ought to love that. This is indeed a version of preservation. Notice, by the way, that in some states, they actually address this issue in a way that does literally eliminate the old covenants from the record. And I personally, when I brought the matter to the attention of the General Assembly and asked them to take a look at what various other states have been doing, it was my suggestion and was agreed among those who in the legislative statute writing section down at the state capitol. It was their view as well that we ought not to literally obliterate the history. It ought to be there. We ought to be able to look back and see that these things are there. And yet at the same time, these forms, these affidavits and forms can help to set the record, basically set the record straight and can show, as to borrow a phrase from Martin Luther King, that if you go back now and you look at the arc of history, that in fact that arc of history is bending more toward justice. So when I get to this point in talking about this with folks like yourself, I like to say, well, now you know about the Public Act, and now you understand why it can be considered important for people who have these kinds of provisions in their title history. And so now that you know and you understand, what I like to do is I like to encourage people to use the new law. So I would encourage you, spread the word, let people know that the law exists, that there is a way to renounce or reject these things. Take a look at your own property's title history if you like, or if you like, get in touch with myself or my colleague, and we'd be happy to see if we can help go back and if you suspect you may have one of these in your own property's title history, we can see if we can help with that. And also, there's a great resource. There's an online, and this sometimes gets a little awkward because the title of there's a close connection between an online book and the name of the online book being called On the Line, which refers to property lines. But there is this online book that is hosted by a Trinity College professor named Jack Doherty, where he has collected a lot of good information and data and written articles about this subject. And that's a good place to go and look if you're interested in it. Here are some resources. There's a very good general discussion of this whole topic of racially restrictive covenants in a paper that was published by the Philadelphia Federal Reserve years ago, which I found a very readable one. I've listed a couple of relevant stories there that bring the matter closer to home here in Connecticut, both with respect to Hamden and with respect to Manchester. Manchester is my hometown. I came across this topic with respect to the house I grew up in Manchester, and when we got the new law enacted a couple of years ago, it in fact got some publicity. So there's a link to some media coverage of my journey, and there's a similar for the one for Hamden. My colleague June Gold, who's also an attorney and does this kind of work. There's a story of her journey there that you can link to. There's Third, there's my reference to the On the Line online book by Jack Doherty. I've made note that we're trying to develop what we call a known streets list. It's partially there on our website, which we have a website, and you know what? I neglected to put our website, our URL on the slide. And you might want to make a note of this if you're interested. If you go to myctdeed.com, that is a website that my colleague June and I, my colleagues June and Jack and I have created to kind of give you some insight into things and to help people who are interested in the topic. But we are trying to put together where we are pretty confident that there are certain streets where in various towns where you're likely to find these covenants in the title history. We're trying to develop a somewhat comprehensive list of streets, with the caveat that it's not perfect and it's not intended to be perfect. And so please don't hold us to a high level of exactness. There are email addresses for myself and my colleague June. That QR code I thought was a QR code that would take you to our website, but it turns out it's not. But that takes you to Jack Doherty's On the Line online book, which I recommend as a place to go and do some reading and some research on your own. Once again, if you are interested in going to our website, it is myctdeed.com. So I think with that, that's really kind of all I had for my comments that are supported by my slides. And I know we have a few questions, which I'm happy to talk about, and there may have been some more coming in. So Stacy, what do you got for questions?
Second here, I'm going to pull them up. So we have one question that asks, how were towns or cities able to vote on this restriction? So I think the question is whether it's property or whether it happens, town-wide.
Yeah, so the towns and cities do not vote on these things. These restrictions are put in place by individual property owners.
Mm-hmm.
And it's individual property owners and land developers and residential developers who create these restrictions and then record those restrictions in the land records. The town itself doesn't vote to either do or not do these things, to accept them or not accept them. The town clerk's office simply takes these documents into its possession and records them in the land records. So the answer to that question is there is no voting going
on. We have another question, whether you knew if the town of Plymouth had such covenants in place, and I guess that's something that would.
So I don't know. I will put it on my list as a place to look. June and I, my colleague June and I, roughly split up the state geographically. She lives in Hamden, not far from where you all are. And I live in West Hartford. And so I tend to do more of the central and eastern Connecticut, and she tends to do more of the southern and Fairfield County kind of thing. Plymouth is probably closer to me. I'll see if I can get down there sometime and take a look. We don't find these in every single town. There have been places we've looked where we haven't come across them. Our methodology is driven by what I learned in my initial research on this subject, which is that, again, if you look back at the late 20s, 30s, and 40s, what you find is that at that period of time, there was a lot of residential development going on. People who were taking larger pieces of property, filing subdivisions of them, and establishing big residential developments. and it was in the context of those kinds of things that from time to time you would find developers whose thought process apparently was, I'm going to do better developing this property if I put in a covenant that says only white people can live here. And at the time that was considered legal and enforceable. It was pre the Shelley versus Kramer case. So the point is, it wasn't uniform. In some towns you can find these things, and in other towns you don't. What is interesting though is if you go back and take a look at one of my earlier slides where I had the examples of the covenants. Recall that it was apparently a common enough practice that the exact same language was used in several different towns. So although it wasn't completely standard practice, there was nonetheless standardized language that that probably the attorneys in the state shared with one another and used in various towns. So that's a long way of saying, I'll try to take a run down to Plymouth sometime and see if I can find anything in Plymouth.
And then Charlie Jansen, do you want to ask your question that you had submitted earlier?
Yes, thank you. Full disclosure, I've been a real estate attorney in Fairfield County, starting in Greenwich and now in Stamford since 1981. The point made in the chat that these abound in shoreline communities is true. Those shoreline communities were by and large created after in the beginning of the 20th century, when people came out on the railroads to newly developed properties, and subdivisions were created by a series of restrictive covenants or agreements affecting every lot in a parcel, as you described, David. Yeah. Exactly correct, before zoning. Yes. Of note, I had some clients who bought a house in Norotan Bay in Darien, and guess what showed up? A restrictive covenant. But my question relates to religious restrictive covenants, because it was an anti-Semitic covenant. And it's just as illegal and unenforceable. And when I discovered it in the, let's say, mid-90s, came across it, had a big red stamp on it in my title search from the title company and the title searcher, which said something to the effect of, and I think I'm wrong in the summary of my question. I said, violates U.S. Constitution, 14th Amendment, unenforceable. And I sort of recall the word void, but from what you've said, David, you kind of like nailed the last piece of it there.
Yeah, yeah.
So it's troublesome. And I'm a past chair of the former Connecticut Trust for Historic Preservation, and I was always troubled by the idea that something could be erased from the land records, because that does eliminate history for people. So I like very much the statutes that's there, because it preserves it. There's a narrative, I think, that can be told in terms of the sites that have these covenants. It's either there's a story behind it. There's a subdivision, as you described, Dave. There's something else going on. It wouldn't be surprising that they run by streets. So my question to you, having said all of that, I want to say one more thing for the land records. When people buy a property today in Connecticut, you're only required to do a 40-year search. You're required to go back 40 years. That's the Marketable Record Title Act. You might find one of these affidavits if someone's aware of something that's older than that and it shows up in the title. But you would love this idea. I had to do some research about the definition of what is a parish. Is it a town or a church that owns property when you refer to that it's owned by a parish? And that took us into the land records pre-revolution. I mean, they go all the way back to when titles were created by the British and recorded. So I guess two questions. One, what's your thought about the religious aspect of this? Because that's just as fertile in people's minds that I know who have considered moving to Darien because of the past restriction there. And what about this issue of things or disappearing, let's say, from to a present purchaser? Because the only way I would know that there was an old racially restrictive covenant that might be predate the 40-year period, you know, that maybe might be part of just the explanation, or what's your reaction? I think what you're doing is great.
Right. Well, so thank you. And let me take sort of the second one first. I couldn't agree more that a weakness in the statute and in the way Connecticut is doing it is just what you say, which is that it's very unusual for anybody under our marketable title statute to look back any further than 40 years. And so here we are in 2024. You know, if you look back 40 years from now, the fair housing statutes will already have been in effect and will have said you can't create these anymore, and so you're not going to find them. And there's no incentive. I shouldn't say there's no incentive. There's very little incentive for most people, I would say, to look back further into the era when these things were much more prevalent. So I agree with you. That's kind of a problem in terms of, you know, encouraging people to go and find out if they have these things. I could spend a lot more time talking to you about other ideas I had that I brought to the legislature as ideas for how we might try to get the same effect that we're getting with what did get enacted, and yet without having to go back and really specifically identify, without having to go and do the real old title searching, right? But they had a different idea, and they enacted what they enacted. And I mean, the legislative process is what it is. It was new to me. It was a real education. In any event, we've got what we've got. The point is, I agree with what you say, that there's that's a problem with the scheme that we have. With respect to the anti-Jewish thing, it's very interesting to me, and I'll tell you a little bit of a story. When I first got interested in this, I told you that the home I grew up in Manchester, my dad, who turns 99 next week, still lives in that home. And he pulled out his deed and found one of these things, and because he keeps everything from way back then. And he and I talked, and he told me the story of when he and my mother first bought the house, of how the realtor who was showing them the property asked them, "Are you Jewish?" And my father's recollection is that all they did was they responded no, and that was the end of it. And little did they know that, oh, by the way, buried in the chain of title was this racial restriction. So it kind of goes back to how I started this talk, which is to say that, you know, there have been methods and still are, frankly, methods other than formal written restrictions that have operated to exclude people from neighborhoods. And I've always wondered if my mother and dad had been Jewish, and if they had said yes, whether that realtor would have steered them somewhere else, right? And the other thing that I'll just comment on is there has, I'll say, both sociologically and legally, there has been a discussion for a long, long time about whether Jewishness is a race. whether Jews are a race. All right. And I'll tell you that I saw your question before we signed on, and I remembered that when we were looking in the records in East Hampton, around Lake Poketapog, right? We came across a deed with this language in it. The said premises shall not be conveyed or leased to any person of the Jewish race or extraction. Now, there must be some distinction between race and extraction. We could talk about that for a long time, right? But here at least is one landowner who when they conveyed, identified Jews as a race. And I guess I would suggest to you that since our statute says that the deeds that Connecticut considers to be void are those that purport to exclude people on the basis of race, I would say that covenant is covered by the statute, right? Whether or not it's true that Jews are a race, you can talk about that. Even within the Jewish community, there are people who go both ways on that.
Well, that's a very interesting point, and I'm glad you made the distinction because I searched high and low for a copy of that covenant for this conversation, and I couldn't find it.
Yeah.
And home free if it says the word race.
Yeah, right. So some of it may come down to whatever words a particular attorney sitting in his or her office, decided to use in drafting up the covenant.
Okay, I'm not going to take too much time, but I have two follow-up questions. One, it might be very interesting if you find one covenant to then go back and look at adjoining properties and see if similar covenants affect an area surrounding that property.
Right.
Okay. And I assume you've probably done it.
Yes.
In this case, the purchasers, who also happen to be very good friends, the worst type of people to represent, they were actually glad to see the red stamp on the document and to hear from me, well, when you read this, take your finger and put it over that language because that's the effect that it has. Okay, 0. But it is somewhat of there are some folks, it might really bother them that that's in their title. And this is a very powerful thing now I can tell people about. So thank you.
Yeah, you're welcome. Thank you. Thank you for the story. It's great. Anything else?
We've got some more in the chats. Let's see. Has your research on restrictive covenants discovered any associated with historically famous properties or communities? Any that you know of?
Not yet. I'll tell you though, I thought it's interesting whoever asked that question asked it, because I had a thought probably a year or so ago. Wouldn't it be interesting if, for example, the governor's residence, I live a couple blocks from the governor's residence in Hartford, right? And that house where the governor lives, the governor's mansion or the governor's residence, was built in the 20s. And I thought, gee, wouldn't it be interesting if the governor's residence has one of these in its title history? So I went and I researched that property specifically and found nothing to that effect. And the short answer is no. We haven't come across the covenant in other people's properties. Although, I mean, in some sort of famous or prominent people's properties. Although I'm sorry, this memory isn't complete, but I believe one or more of the Supreme Court, the U.S. Supreme Court justices had to recuse themselves from one or more of these cases because they themselves had these provisions in their own title history of their properties. So it's an interesting question. I'm kind of tuned into that question myself, and every once in a while I think, oh, wouldn't it be interesting this person or that happens to have one, in their title history, but we haven't come across one yet. I'm not done looking.
Excellent. So I skipped one question that was in here. Do you have an idea of what percentage of restricted deeds in Connecticut have now had affidavits filed for them? And second part is, are there certain towns that do a better job of spreading the news about this? And have you enlisted attorneys to sort of assist with this? Are there people out there that help besides yourself and June?
So we don't have enough data really to know, but my very strong sense is that it is a tiny, minuscule, almost unobservable number of affidavits or forms have been filed so far. The law is not widely known and not widely used, at least not yet. And we don't really have, I mean, there's only a handful, literally a handful of affidavits or forms that June and I know of that have actually been filed. Now, that's not to say that people don't know about it. But frankly, it's one of those things where the word isn't widely out. I did a presentation similar to this for the Connecticut Bar Association, and I encouraged them to see what they could do to work with the knowledge of this new statute to see if we could get it more in use. And like I say, I don't really have data. My very strong suspicion is it is not widely used.
And let's see. MJ, do you want to talk a little bit about your grandparents' experience? You mentioned it here in the chat.
Yeah, sure. My grandparents bought a house in Niantic, and David, I could probably get the deed for you too and send it to you. But yeah, it was a development that was established in 1921, and there was restrictions, no Italians, no Jews, no Irish, and I think maybe no Polish were specifically written in there. And she wanted to buy this property. My grandfather had passed away, and so she had a friend who was Dutch, and he bought it from the developer, and then in turn was still able to resell it to my grandmother, who was all Italian. And I guess it caused a lot of uproar here at the beach, and because I live in the same beach community that she did, and we still own that house. But yeah, it was a big deal back then, and it was right in the deed. And it's still, I mean, I could get the deed from East Lyme Town Hall, but this whole community was had those restrictions in it. And I think the lawyers, when they go to transfer property, at least in this county, they just drop it. They just drop that restriction when they do, like you said, they only do a title search going back 40 years, but like my grandmother's owned it since 1942, and it's still in our family. So if somebody were to do a title search, they'd have to go all the way back to her deed because it hasn't been resold since then. But the attorneys here have just dropped that restriction out of the deed, and when they've created the new deed. So
well, let me say that I think a very common practice among attorneys throughout the state is to use language like I found in my father's deed, where it said subject to restrictions of record, so that the deed that my father was given for his house when he bought that house, it was like the third or fourth time that the property, that lot that his house was built on, the third or fourth time that lot had been conveyed. And it was only in the first deed out from the original developer where you found the explicit racial restriction. Every conveyance subsequent to that only had the language subject to restrictions of record. So you'd have to go back and see, well, what are those restrictions of record? You'd have to go back and do the further title search, which is your point and a very good one. So And also another good point, which I concur with is that very, very often these kinds of restrictions are found because they were commonly done by developers for an entire development, for an entire subdivision. If you find them, on Maple Street, in the Maple Heights subdivision, you're going to find them on every street. Or commonly, you find them on every street in the Maple Heights development, if you know what I mean.
And Louise, we're not ignoring your question either. Are you here? Do you want to ask your question? Oh, we can't hear you. I think. Hello? I think Jordan sent you a private message. We can chat offline too. One thing I did want to bring up is, I don't know if any of you are aware of the Village Creek National Register Historic District in South Norwalk. It's just as a point of interest. It's a National Register District listed in part because in 1949, when it was formed, the Homeowners Association created a covenant that ensured racial integration. So it's just something of interest if anyone wanted to take a look at that and sort of.
What's it called?
Village Creek National Register. It's still the Village Creek Homeowners Association maintains the same language in their covenants now. But in 1949, they ensured that there was diversity in their community. And as a result, they were called Commie Creek, and all sorts of accusations were leveled against it. But, it sort of took a real hard stance at a time when these covenants that you're describing were common.
Well, that's very interesting because that's immediately following the Shelley versus Kramer decision where the Supreme Court, ruled on this thing. Tell me again which town that's in? That's
in Norwalk.
Okay.
Yep. And it was listed on the National Register in 2010, in part largely because of this covenant that they do have in place.
Thank you.
So thank you. Thank you for all of this information and for sharing this with us today. I hope that we can spread the word. This will be recorded and live on our website. So not just the people who are here today will be seeing it. And I hope everybody takes this and shares it. Thank you very much.
Right. Well, thank you for having me. I appreciate it. Thanks.
Thank you. Thank you for your work. Take care, everybody. We'll see you next week. Next week, we're going to be sharing a project by our former intern who has created an LGBTQ map of sites in Connecticut. So please join us for that. It's going to be pretty fascinating. Thank you.